This is actually a good point for me to digress a minute about the New Jersey tax structure, because it looms large in the planning process. New Jersey is an incredibly aggressive tax state. They are one of the most expensive and complex estate tax structural states in the country. So, for example, and here I'm just going to stick with New Jersey for the moment. New Jersey has two different kinds of death taxes. These are taxes just based on the fact that I've got stuff, and when I die, I'm giving it to you. They don't have a gift tax. However, in other words, a tax imposed on that same passing while I'm alive. However, they do bring back into the estate transfers that I made 3 years before I died. So if you happen to be so unlucky as to make that really wonderful gift and then die within a 3-year period, effectively New Jersey has a gift tax. So the inheritance tax is a relationship-based tax. They focus on what the relationship is between the giver and the givee. So they'll allow an unlimited exemption from the inheritance tax. We'll go to the estate tax in a minute, but keep in mind we're talking about only one of New Jersey's wonderful death taxes. So the inheritance tax says if you give it to a spouse, a child, a parent, a grandchild, so it's basically linear, up and down, and spouse, there's a 100% exemption. If you give it to a sister or a brother, and those kinds of relationships, then the first $25,000 is exempt from tax, but everything over that is taxed at between 11 and 13%. If you give it to a charity, there's also an unlimited exemption, but of course New Jersey can't do anything simply. So if you give it to a charity that does not honor that's in a state that doesn't honor a New Jersey charity, if it doesn't have a reciprocal arrangement, that New Jersey will not accept that as an exempt inheritance tax transfer. And then everybody else is what's called a Class D beneficiary. All transactions without a floor are subject to tax if you are a Class D beneficiary. And the tax rate on that is between 15 and 16%. So for example, if you leave your best friend or your godchild or your housekeeper $10,000, you're paying $1,500 in tax. So maybe you're okay with that, but whose pocket does that 15% come from? If your will is silent on which pocket it comes from, it may be that it's coming from your wife's share, your husband's share, your children's share. So it's important to know, number one, that the tax exists, and then number two, it's important to decide whose pocket it's coming from. So in addition to the inheritance tax, I'm sorry, I just want to go over one more thing. Let's say you have a trust under a will. You've said, I want everything to go to my wife for her lifetime, and then on her death, I want it to go to my son-in-law. The daughter is deceased, the son-in-law is special to her, and I want it to go to the son-in-law and his new wife. So if the daughter is deceased, or if there are other issues, you can have that be a Class D beneficiary. When the first person dies, when the spouse dies, and they've left this trust for the benefit of spouse who's exempt and non-exempt remainder beneficiaries, when you die, New Jersey says, I want you to calculate now how much the likelihood is that that person who's a Class D will inherit. So they have you fill out what's called a compromise tax calculation. I have to figure out what's my wife's age, how long, what's her physical and mental well-being, is she going to live for this period of time based on the actuarial tables? And then if she doesn't live beyond that time, what the likelihood is of these people inheriting? Are they in okay mental health? Will they predecease the remainder who is a Class A? So the calculation is incredibly complicated and expensive on the death of the first spouse, potentially, where people usually think there's no inheritance tax because it's going to a spouse. So when you are planning in your estate planning documents, in your will, to consider these issues, at a minimum, pay attention always to who the beneficiaries are, including the people who will take right away and the people who will take later. And then, in addition to paying attention to that, also decide whose pocket the money comes from. So you're having this conversation with the client. Do you want, if you're giving the housekeeper $25,000, I have this conversation with clients all the time. $25,000 they want to go to a housekeeper or a godchild. Do you want them to get the $25,000, or do you want it to come out of your children's pocket? And they had, it's an engaged conversation. You've reflected with them, and you know what to do. So that's New Jersey's inheritance tax area. Then New Jersey has the estate tax, which is another death tax. So let's say everything is going to Class A beneficiaries. It's going to a spouse, children, grandchildren, all exempt, nice and clean. Spouse is dead. Surviving spouse this is the second spouse to die. You would think that there would be no tax due to New Jersey because they're all Class A's. But New Jersey has another tax based on the exemption that was allowed by the federal government in the year 2001. At that time, that exemption was $675,000. So the net of this is that in New Jersey, if you have an estate going to children or grandchildren or people that you would otherwise think to be exempt other than a spouse, then you're going to have tax on amounts over $675,000. And that can also be something of a shock as well. So one of those things that people want to be prepared for is, do I have an issue again? Do I have to care about it? I also want to mention that the estate tax construct is linked to the federal rules, the Internal Revenue Code. The Internal Revenue Code says that if you have a non-citizen spouse, so the surviving spouse is not a citizen, then transfers on death to that spouse are not exempt.